So non-court dispute resolution is the big thing at the moment in litigation. We've just got some new rules, new practice directions. The idea is that judges are trying to move cases out of the court process and get people to resolve things between them. So that it covers a multitude of sins. It's anything that isn't a court. So it can be anything from mediation, collaborative practice, roundtable meetings, anything that keeps a couple out of the court process. It can also be what I prefer to refer to as quasi court dispute resolution. So that is where a couple have got to a point where they can't reach agreement. Sometimes people start off with that, and they need some help. So they either need what we would call an early neutral evaluation, which is usually a retired judge or a barrister or a solicitor who you pay to give you some an indication of how they think the settlement could be achieved and to support that negotiation. Or you can have an arbitration, which is an adjudication. It's like a final hearing at court, and it's a decision that's made that's then binding. So all of this comes under the heading non-court dispute resolution. So at Jones Myers, we will support people to go through the separation process in whichever way suits them best. So we essentially, we cover most things. So from the least invasive way forward, so the method that's furthest away from the court process, I would say that's probably mediation. So we offer a mediation service here. I'm a mediator. So that involves the couple talking together, usually meetings based. It can be shuttle, it can be remote. There are various different models, but essentially that is one impartial professional, that will be me, helping a couple to talk about what issues they've got and to resolve them by agreement outside of the court process. There's also a collaborative practice. So again, I'm a collaborative practitioner. Collaborative practice is where each couple has their own solicitor around the table, but the couple and their lawyers sign out of the court process. So they sign agreements to say that we will sort this out around the table, and that's collaborative practice. There are more traditional ways where solicitors will work with solicitors acting for the other person. So they'll try and resolve things out of the court process in correspondence using roundtable meetings. There's all that kind of, all those options are available to couples within this practice. We also support couples who need to have an adjudication. So sometimes when they get stuck, there are various different ways in which they can be helped. Sometimes that's by bringing in an impartial professional. So they'll each have their own solicitors. We would only act for one of them at that point. So we would then go to usually a barrister who offers this kind of service. There are some solicitors that do it, retired judges, etc. And we would put the case, each party would put the case to that person, and they would then give their view as to how the case should be decided, and that's to support a negotiation. Ultimately, if no agreement can be reached, then they could apply to an arbitrator, so agree that there'll be an arbitration, and that arbitrator hears the cases and then makes a binding decision. So all of those things are still outside the court process. Arbitration and early neutral evaluation really mirror the court process, but there are advantages to those which I can talk about. I think it's really important to have a really good conversation with any new clients, anybody that walks through the door. That enables you to understand what's going on for that particular person, what their priorities are, what the issues are, how the communication is between them and their separated partner, and that enables me then to get a flavour and to suggest options. But at the end of the day, it's that person's decision, it's the client's decision. It's not for me to impose a particular way forward on them, but to give them guidance so that they can make the choice that's right for them and their family. So NCDR, it's the same thing, really. Whatever process you use, NCDR covers a range of different options, different process options. They all lead to the same point, which is a binding agreement. It's how you get there. And I think how you get there is one of the most important decisions that anyone will make, because where you get to will probably be about the same, but how much damage there is in the process and how much money and time you spend in the process can differ very greatly depending on the process that you choose. So whichever way anybody chooses, we will provide support to them. So it might be more hands-on. If I'm mediating, clearly that's going to be me in the room as the impartial professional trying to help a couple to move through things. Collaborative practice, I will be just working with one of the couple and giving them advice and support as we go along. If it's through a court process, if it's through an early mutual evaluation process, arbitration, the client service remains the same. It's just making sure that that process option is the right one for them and providing them with support in what is, whichever process you choose, can be quite an unpredictable journey. So whichever dispute resolution process you choose, whether that's mediation, collaboration, roundtable meetings, solicitors' correspondence, the court process, it all ends at the same point, which is a binding resolution, a consent order, a child arrangements order, whatever that might be. The difference between court and non-court dispute resolution is the process, it's how you get there. So in processes like mediation and collaboration, you have conversations, you get to an agreement, but you keep control of that. That's the key difference. You're making the decisions, and those decisions are then ratified by court and made binding if that's the right thing to do. The other processes, sometimes it's a little bit different. So arbitration is like a final court hearing, so the decision is made by somebody else. You're handing over control for that decision. But again, it's a binding decision. It's just you haven't agreed that, that's imposed on you. So there's no difference in terms of enforceability of these agreements because they can all be ratified by the court. And the court process is designed to try and help people to reach their own agreements, which are then approved by courts and made final and binding.